Hey, everyone. Happy New Year.
Hello, everybody. Hope everybody had a great New Year. We'll give everybody a few minutes to jump on here. Then we'll get started. For anybody that's new on here, I've pinned the email address at the top. And then the website and the email address is in the description for tonight. So yeah, we can.
Yeah, I've already talked to him about it.
Okay. And I'll just put them all in there.
We'll just give it a few more minutes while people come on.
No.
Yeah.
Okay. All right, you ready?
Yeah. Okay. Okay, if you want to bow with us in prayer to get started. Dear Heavenly Father, we thank you so much for this time together. We ask that you would just watch over each and every one of us. Help us to be a light in this dark world to people that are struggling with the inflation, job losses, and tough times that we've gone through over the last couple of years. We ask that you would just rain blessings on this new year and that you would just bring us together to learn from one another so that we can do your work for your kingdom. In Jesus' name, amen. Okay. So tonight we're gonna do education. This is for educational purposes only. I'm not telling you how to do anything. I'm just giving you some facts about how the banking system works and how promissory notes work. And that's what tonight is about. We don't have any updates to give you other than we've been asked to stagger paperwork being sent in. So we're limited as to how many we can send in due to the backlog. So there's a lot of things that are out of our control. But that's where we are with that. That's the only other update that I have. All of the other updates are the same as what you've heard on the last couple of lives. So I want to let you know before we get started that we do have a trust group. If you're interested in getting a trust set up, you can go to the Telegram is going to be pinned It's an open link for tonight's live. You can go in, you can join the Trust Telegram group. That group of individuals that own that company are helping our people to get their trust established if you would like to. And you can do a free consultation. You get a free consultation by filling out their intake form when you go into that link. We also have a land patent group, a land patent expert that is handling that group. If you're interested in a low deal title or land patent, whether you have your home paid off or not, you can go into that group and start learning about land patents and how to start getting one filed if you have a property that you have even a mortgage on. He'll walk you through the steps and how to get that done. And that link will also be open for the allodial title and land patent group and the trust group. So,
sorry, I'm trying to find the account so I can put the links in.
Okay, so I think that's the only announcements that I had. If anyone is interested in getting their status corrected, we're almost caught up on that. Pretty much are caught up on that. If you sent payment and you haven't received anything, there's a chance that we didn't get something that we needed from you on your end, and maybe we don't have your contact information. I know some people just paid us and didn't send their paperwork to us. So if you haven't received anything, we're pretty much caught up on status corrections. And if you want to get that done, you can reach out to us with status correction in your subject line, and I'll drop you the information regarding that. We do have a secure party creditor process that is going to be coming out. We have a group that's handling that also, and that Telegram page will be opening soon. Well, it's going to be opening this week. So when we go live again, we'll put a link out here. But if you're interested in secure party creditor process, you can always send us a link. Send us an email with SPC in the subject line, and we'll get your information taken down and drop you in that group. So we're just trying to provide resources for everyone to get their processes done, because Drew and I can't handle everything. So this gives us, people that can help you and resources. So MMS, if you haven't heard of MMS, a lot of people are seeing significant healing or benefits from the MMS. So we have people that have cancer that are on the MMS. We have people that have had, I have one lady that had a really bad car accident and was injured really bad, and she has not been in the pain that she was in prior to taking MMS, hasn't had to have her cortisone shots or pain shots, things like that. So it is we have a video of it up on our YouTube. On our not YouTube, on our
Telegram.
On our Telegram. Yeah, we have a Telegram MMS channel. And we also have it on our website, I think. If you're interested in MMS, you can drop me an email, and we'll get you that information sent out so that you can watch the video. It has nothing to do with Drew and I. It has to do with, it's a universal video. What else before I get started? Non-toxic products. If you're interested in the non-toxic products, we are opening a Telegram link for that too. So you're not having to wait on emails to come to you. And we also have a precious metals group that just opened on Telegram also. And that way we're not having to deal with everything and spend time getting back to you. You'll be able to be in that group and we can go from there. So, all right, so let's get started. So I don't know how many of you know what an actual promissory note, we all know what a promissory note is, but how it's handled by the financial institutions, a lot of people, I feel, don't know all of the procedures of how it's handled behind the scenes. So I wanted to go through that tonight. For mortgages, for just regular loans, for loans that you get over the computer, or auto loans or mortgage loans. All of these are handled in the same way. However, a lot of the loans that you get online are unilateral contracts. A lot of them don't have two-party signatures, and without the parts to a contract, all of the parts to the contract is not a binding legal agreement. So, if you have loans that you've done over the computer, you might want to pull your contract and see if anybody signed with you on that. Otherwise, you're in control of that contract. I know when you go into an auto dealership, if you do a promise or you do a sales contract with them or a promissory note with them, they're going to have themselves as the lender, which means that they're selling that paper. So if you have an auto loan, look at your auto loan paperwork, and in the creditor section, it's going to have the name of the dealership, and it's going to have them as creditor, and then it'll show you who they're selling it to, which means that they have to have their license in the state because now they're a debt collector. So every state is different with what form or license, whatever form, right?
Form 2901, I know, is for the state of Texas. They have to file that with the Secretary of State and put a $10,000 security bond up to be a debt collector. In Texas, you can also go and look on the Secretary of State's website, and you can type in a company to see if they actually have a bond with the Secretary of State showing that they can actually collect a debt in Texas.
Yeah, so that's basically what dealerships are doing. They're taking the paperwork, they're acting as creditor, they're selling that paper to a financial institution of some sort, and they are in charge of collecting the debt. But you don't have a signed contract with who you think is your lender for your auto. Probably isn't really who you contracted with. So just look into it. Every contract is different. So just look into it and see what yours says if you have questions about that. But I'm just going to go over a little bit about it. So modern banking was created in Babylon over 4,000 years ago without the means of the electronic information we have today. The bank and lending institutions does not disclose to the public that a promissory note becomes an asset of the bank the moment you sign it, that they deposit it in the bank as their funds. The bank does not tell you that a promissory note is a negotiable instrument according to the Uniform Commercial Code, that the bank will deposit in the bank to fund your loan, that the bank will deposit, nor that the bank has a liability to you of nearly the same amount of the loan. By their own bookkeeping entries, according to the general accepted accounting principles, the bank then owes you nearly the same amount of the loan. So what the bank doesn't tell you is that whenever they take that promissory note, they monetize the back of that promissory note. They deposit it into an account that they set up for you in your name. And then they ask for the interest and the fees and all the things associated with it that you pay back over however many years or months or whatever the situation is. But the bank doesn't tell you any of that. That you, in fact, provided the actual loan or the value of the loan. The bank only appears to be lending you an asset of theirs, but it's actually your asset. So the value is first given to the bank by way of your promise to pay. So your promissory note is a promise to pay, but the bank deposits that asset you give them into the bank as a value that funds the bank's loan to you. And that's how it works. So you want a loan for your home, your car, whatever. The bank advertises that they loan money. You apply for a loan. They put you through the ringer and make you thankful and relieved that you actually got the loan. And lastly, they have you sign a promissory note. And here's the part that you're not supposed to know, that since your promissory note can be sold for money, it is an asset just like cash. The bank deposits your promissory note into an account listed in your name for the amount on the note, less a few bank charges. The bank then cuts a check from the deposit in your name that you never knew you had, or transfers the money to the people that you want to receive it. You think you owe money back on a loan that you funded with your promissory note, when in fact the transaction was of equal exchange. So if the promissory note is an asset to the bank, what paid for the bank's ownership? Well, the bank really does not own the note. So there's a couple of books that you can read that talk about this in detail, and I want to give you the name of those. So the Federal Reserve Bank of Chicago came out with a very revealing publication back in the 1990s called Modern Money Mechanics. That's a really good one to read. And then also, let me see if I can find the other one. The Creature from Jekyll Island by G. Edward Griffin. Those two really talk about the money system and how it was set up. So if you want to learn more about it, you can go to those. But also, let's continue on. After all, they deposited your promissory note as a bank asset in their bank that they could sell and then exchange that asset back to you, calling the exchange a loan from the bank, when in fact it's an exchange dollar for dollar. And then they expect you to pay the bank the value of that equal exchange in payments of principal plus interest that you do not owe. Your promissory note is an asset that they took in exchange for the bank check that they gave to you. So where is the loan? There isn't one, because it was already a dollar for dollar exchange. Now they're just requesting that you pay interest and fees and all this. Since all the lenders should be repaid, the bank should repay the loan they took from you via your promissory note. It would be a washout. You couldn't have a debt that you think you owe that you really don't owe. So your signature on a promissory note and a promise to pay creates the actual value of the promissory note. We've talked about that. So most of you already know that. But the bank exchanges value for value, just like our government and the Federal Reserve do. And then they lie about it and call it a loan of credit, but it does not lend. You and millions of others are led to believe that you have a debt. This is similar to counterfeiting, swindling, and stealing. Our founding fathers knew about this type of banking. This is why they made provisions in the Constitution of the United States of America to stop this system of banking from infecting our nation. It is in Article 1, Section 8, Clause 5. In Article 1, Section 8, Clause 5 of the Constitution says, Congress shall have the power to coin money, regulate the value thereof, and of foreign coin, and fix the standard of weights and measures. And then Article 1, Section 10 says, no state shall use anything but gold and silver, coin, a tender, and payments and debts. We've gone over that many times. Sometimes repetition is best, though. So whenever you, when the bank, so they basically alter your note, because they don't tell you that they're going to monetize the back and that they're going to put it into an account with your name on it and all of this. So did you give the bank permission to change your promissory note into money? I didn't. When the bank altered your note and changed it into a negotiable instrument, They transferred more than twice the cost they received from you and all the risk to you. They more than doubled the cost to you by demanding payments plus interest and transferred all the risk to you by demanding collateral that they could seize for non-compliance with their terms. This is for mortgage. This is for mortgages, auto, anything that has collateral attached to it that they can come and take. But because of the banking fraud, you're in debt to the bank for money that you provided the value of in the first place. So let's see, I recommend the book Modern Money Mechanics from the Federal Reserve in Chicago, because it goes over all of that. And then here's a couple of other books called The Two Faces of Debt. The Federal Reserve in Chicago did this one too. It's called The Two Faces of Debt and Hats the Federal Reserve Wear. So in case anyone wants to read any of those books, or if you have, you can learn a lot. And then the Federal Reserve in New York published a book called The Story of Checks and Electronic Payments. So, I would recommend reading those for sure.
Somebody else put up here, Fruit from a Poisonous Tree.
Oh yeah, that's a really good one. They actually, if anybody has a Scribd, they have that book on Scribd that you can download and read, just to save you some money if you're already on Scribd. Okay, so these publications tell exactly how the banks work, and it'll give you information on how to challenge the loan and the illegal actions of the banking community. That's why I'm recommending that you read these. So if you want to put them in there, those three. So banks act as exchangers. They exchange security interest, promissory notes. So security interests are your promissory notes. I know a lot of people that are learning about secure party and stuff like that get confused when we talk about exchanging securities and stuff like that. It's basically just exchanging your negotiable instruments, your promissory notes, for Federal Reserve notes. Kind of like exchanging euros of a particular exchange rate into dollars of a different exchange rate. So, okay. Let's see here. So you're getting a loan, you're exchanging one form of security for another form of security. Let's see. Let me find so let's go over this. The promissory note that you signed is a one-sided contract. That when you sign it, you give your rights away to the bank in exchange for absolutely nothing. Being a one-sided contract, meaning you were the only one who signed it. So you'll have to look and see if you are the only one that signed it or not. In some cases, you're not. Some cases, somebody else signed it with you, but in a lot of online cases, you signed it and they didn't. So it gives you the legal option to change that contract if you discover that it is not working in your best interest. The fact is that the promissory note you signed is probably based on non-disclosure, which voids any contract. Nearly every promissory note written by a bank or finance company is based on deceit. Here's some of the deceit that you can, so if you want to kind of take note, here's the parts to the contract that you have to have, and this is where they deceive you. You have to have consideration in a contract. So if they don't, the lack of consideration, all contracts must have consideration to be valid. The note you signed, which the bank monetized, turned it into money and deposited in their bank with no consideration to you. Your exchange was a gift to them and a charge to you. And in return, your gift to them, you were given a bill of the same amount, which you had to pay for 30 years or 7 years or 2 years or however long, depending on what kind of loan promissory note it was. So you've got to have consideration in a contract, and you have to have disclosed everything. So you've got a non-disclosure of the use of a promissory note in your signature. You were told they were going to open an account in your name to monetize a note you signed. This is part of the fraud, okay? So they did not tell you they were going to open a bank account for you and deposit that money in there and monetize it with your name, which could also be considered forgery. If they monetized it with your name and you didn't sign it, that's forgery. So non-disclosure of the monetizing of the promissory note. You were not told about the process of monetizing a security interest. Non-disclosure of the bank's relationship to the trustee and beneficiary. Most banks own and control the trustee and beneficiary specified in the contract note. This is illegal and a conflict of interest. This makes a note in its present form void. So, and again, forgery. If they signed your name on the monetization and did not tell you about it, that's forgery. So, that's why whenever we talk about discharging debts and how to go after and kind of battle to get your debts discharged, that's why you want to ask for. I did a writ of discovery. I came up with a writ of discovery. I'll put it on our website so that you can go under library tab and find it. But it asks for the promissory note, the original promissory note, any monetization on front and back of the contract, which we've gotten ignored on all of ours because no one has signed it with us. So they don't want to give up the monetization either because that shows the fraud. So, but if you ask and they don't respond and you look at your fee schedule, when you get your status corrected, you have a fee schedule. When you look at that fee schedule, lack of response, there's a fee for that because under the Freedom of Information Act, you're allowed to ask for any IRS documents, OID forms, monetized documents that have been used on your behalf using your name. So if they don't provide it, there's a violation. So question, if they do this, then why do we get denied for credit? We shouldn't. That's fraudulent too, by the way. You are the credit. So why are they denying you? The only reason, I mean, they blame it on credit score most of the time, which is also fraudulent. But I'm still working on fighting that. So all of you that have joined in the fight with that, I'm trying to see what's going to work. So I'm not dragging a bunch of people through unnecessary documents. But they base it off of, they say credit. I'm not sure. I know that some banks from the Treasury, they're only allowed a certain amount of money per month to loan out. I don't know how that is. You can look up how people become banks or how banks become financial institutions, and it tells you what their limits are based on what level of banking they are. So I don't know if it has to do with that, but I can't answer that question. I wish I could because they can't deny you credit when you are the creditor. So there's some situations that I'm going after too because they violated our right to obtain credit when we are the creditor. So I'll let you know how that goes. As of now, I just started doing that. So, and I'm helping some other people with that, but just friends of mine. I'm not offering that. I don't have the time. But here's what I would recommend. When we recommend that you read the above mentioned, so those books that I named, but also USC Title 11 and 12. Because USC Title 11 and 12 talks about banking laws and what they can and cannot do. So by law, the banks must give adequate and fair compensation to you for your promissory note. And per law, under 12 USC 1813, that's 12 USC 1813, They must give you a deposit receipt when they deposit your promissory note into their account established in your name. I've never gotten one. I don't know if any of you have ever gotten a receipt that by law, the banks are supposed to give you when they sign and monetize the back and deposit into the account that they set up for you. You're supposed to get a receipt for that under 12 USC 1813. So I know in the promissory note that you signed, there's a phrase that says for value consideration. This has been used in a court of law to say that the consideration that they gave you was thought, and you didn't object to it before you signed the note. This is the reason for filing an amended note. So if you have a unilateral contract, I haven't done this. So if you have a unilateral contract and someone did not sign it with you, you own the rights to that contract, and you have the right to amend that contract to fit what's going to benefit you in a reasonable manner. Okay. But this is why you have the right to file an amended contract, but you must specify that it's for valuable consideration, because that wasn't presented to you. So, all right, and then we're going to go into, so let me go to mortgages while we're on the topic. And there was a court filing, a Supreme Court filing back in like 2010, around 2009, 2010, something like that. MERS, MERS. So MERS is a Florida-based company that allows mortgage companies to put their name on the titles or on the security interests of your property instead of putting them, so that if they sell that note to another lender, and another lender buys the note, then they don't have to go and refile property tax documents in the counties and state. So MERS allowed their name to be used for all mortgages. Well, in somewhere around 2009, 2010, they were taken to Supreme Court. And the Supreme Court ruled on it that due to the recent ruling by the Supreme Court, MERS is not the title holder. They don't have a real party in the interest of any property, and never have. All mortgages, past and present, are therefore fraudulent. This was a devastating repercussion for all of the loan industries, not just MERS, because there's no longer a chain of title. So I know that California, right when that happened, California got on board and took action in suing MERS for filing false recordings with the county recorders in every county in that state. And since MERS started filing those over 10 years ago, that was a significant amount of money. I don't know what the complete outcome of that was, but it was in 2009, 2010. You can look it up. But that's how they were kind of skirting around that situation, because mortgages, they're sold and sold and sold again. And also, if you have your status corrected and you have that fee schedule, on the fee schedule, it shows that if you have a mortgage that has been consistent for more than 5 years and they haven't provided a remedy, with your negotiable instruments, then it's a $6 million fine. It's a $6 million violation under the Constitution. So, because mortgages are exactly what they're called. Mortgage, dead. The first reason for this, so the company MERS, that's abbreviated, is called Mortgage Electronic Registration Systems. So that was the Florida-based company that I was talking about, Mortgage Electronic Registration Systems. I don't know if they're still in business. I haven't looked them up, but this is kind of how it is, and they bundle those mortgages and they sell them to lenders, and then they resell them and they sell them, and so they're getting paid over and over and over from the Social Security number, your account number. So let's see here. So yeah, mortgages are fraudulent. You want to touch on what a mortgage means while I'm looking at my next part here?
I mean, all I know is it means death, dead. I mean, so anytime you get a mortgage, you're getting something that's dead.
Yeah. So let me see here if there's anything. So I know so any of you that are fighting foreclosure or have family friends that are fighting foreclosure, the Real Estate Settlement Procedures Act, RESPA, was developed and designed in 1974. It was enacted by Congress in 1974 to stop the fraud that was going on against anyone involved with the act of making loans. So RESPA is under 15 USC Chapter 27, Section 2605. So again, 15 USC Chapter 27, Section 2605. The very first thing that we recommend is to send the lender a RESPA request. So if you're going through a foreclosure process, you want to send them a RESPA request. This puts the lender on notice that you think something in their behavior has not been appropriate. Okay, this is a very good tool because more often than not, they will not answer it. Or they will give partial answers and say, I hope this satisfies your request, which is what most of them do. They'll send us one of them sent an amortization schedule, which we didn't ask for. So, but it's just a ploy to relieve them of any responsibility that they have and hoping that you're going to shut up. And then after 30 days, if they did not send what you requested, you sent, and this is with anything. So I'll put the writ of discovery out on our website tonight, whenever I'm done here. Whenever you send that, you're going to allow, in banking rules, you allow 30 days for them to respond to you. And then you're going to allow 21 days, send something else, and you're going to allow 21 days. And then if they don't respond to that, then they have 10 days the third time. And then you've satisfied all of the banking laws to go after them. So after 30 days, send a notice of default with opportunity to cure. And when that is not answered, send them a default notice. Okay, keep copies of all of your letters. They may be important in the future, especially if you have to go to court or file a lien with the Treasury or something like that to collect on your behalf. Also, send all mailings certified, return receipt requested, with a declaration of proof of mailing. So you can put a cover letter that says, this is a declaration of proof that I'm mailing this, signed by a witness, any witness. You can do your thumbprint and all that too, because that's just like having it notarized. And then notice that that's the steps of sending that to try to get a response to cure it. If they don't respond to that, then that's a RESPA request. So then RESPA has to, deal with the mortgage company from there. But when you go through RESPA under 15 USC that Drew put out there, 15 USC Chapter 27, Section 2605, that's providing you some sort of help and remedy if you're going through foreclosure stuff. So let me see here if there's anything else. So So the trustee is given the power to foreclose and to sell your home at a trustee's sale, or to give the task to the sheriff. If you change the trustee to someone you can trust, the bank cannot foreclose on your home without your trusted trustee's permission. Usually the trustee that the bank puts in the promissory note is a subsidiary of the bank. This is against federal law, Title 12. So remember, read Titles 11 and 12. That deals with banking. So the banks have gotten so arrogant in their belief that no one will challenge them that they do this with a blatant disregard of the law. So if the trustee is changed to someone you trust and is actually interested in protecting you, then the bank will not be able to foreclose on your home without just cause, and the banks have no just cause to foreclose because they have no legal authority to do so. So the rescission of power of attorney. So you can rescind the power of attorney that you have signed off on that note, or that promissory note. You must rescind this so they cannot appoint someone else who will act in their best interest. A sample of this notice, I don't have a sample of it, but in here, they're supposedly said there was one, but there wasn't. So, but the Real Estate Procedures Act the Real Estate Settlement Procedures Act, which is RESPA, is a law passed by Congress to protect consumers from predatory lending practices. Title 15 of the USC is something you should read for real estate. It deals with foreclosure and stuff. And then let's see if there's anything else. But yeah, when you're going to fight any of these promissory notes, if you're going to fight any of these debt collectors, you're going to want to make sure that you have requested the monetization, any 1099 OIDs that have been filed on your behalf, or on behalf of your name or social. You're going to want any promissory note that was signed. If it is a debt collector, you're going to want to ask them for their form for the state to be a debt collector. We have found multiple companies that are not licensed in multiple states. So you might think that they are, and they may act like they are, but if you go and look them up, we found a lot of them are not licensed in the state that they're trying to collect. So that's a very important thing to pay attention to. So the Fair Debt Collection Practices Act, the FDCPA, codified at 15 U.S.C. 1692, stipulates that a debt collector must validate.
Sorry, I was trying not to cough.
Must validate an alleged debt by affidavit, oath, or deposition, and cease all collection activity until validation is provided. Validation or verification is defined as confirmation of correctness, truth, or authenticity of a claim to assure good faith and affirmance of statement of party. A debt collector must swear true, correct, and complete that an exchange of valuable consideration has occurred that allows him to demand payment. The signature of the maker is often missing from the note, making the note illegal. So the 5 essential elements of a lawful note are a signature of the maker, signature of the receiver or the borrower, due date or dates, specific amount, and clear sentence of intent. The defendant's promissory note supplied the credit for the sale. In return for the defendant's promissory note, the bank leased the defendant's credit back to him as rent for 30 years and holds the title to the property for having supplied nothing to the transaction at all. The defendant's promissory note has been sold many times without his knowledge or consent, although the defendant's promissory note still belongs to him or her. In monetizing the borrower's promissory note through fractional reserve banking practices, the bank increased its wealth by more than 9 times the value of the promissory note and still demands that the borrower pay the bank the principal of the note plus interest on the credit that the borrower himself provided. Americans have been engaged in commerce on a promissory note standard instead of a gold standard since 1933. So you can find all of this again in Article 1, Section 8, Clause 2 of the Constitution. We've gone over that many times too. The borrower's promissory note, it created the money that the lenders gave back to you for the loan. However, there is no real loan. The bill of exchange that the bank gave the borrower was worth more than 9 times that dollar amount to the bank when the borrower's promissory note was monetized on the discount exchange market and through fractional reserve banking practices. Bank officials expect the alleged borrower to pay back the non-loan that he or she received as his own credit in changed form, plus the interest he is expected to pay the bank on the non-loan over however many. This is more talking about foreclosure, but it applies to any loan. So I guess I'll stop there. Let's see. Let me go over a remedy here and then we'll stop. But when the gold standard went away, when the gold standard went away and there was no more gold or silver to pay with, they had to give you a remedy in how to discharge your debt. So again, for anybody that's new, all remedies are under HJR 192 of 1933, Public Law 7310, Article 1, Section 10 of the Constitution. So the fact that there's actually no money in this country and that the economy is completely based on promissory notes backed by bonds that are backed by the labor force of the American people means that we can pay for our alleged debts the same way the government and banks do. We also are creating a process for those who have actually lost their home can be reimbursed from the loss or damages awarded. So there is remedy. If you have lost your home, if you have been foreclosed on, there are remedies for that also. So you might be able to get some of that money back. So in closing, you are what you think and you create what you focus upon. Your life is in your hands. And if you don't like what's happening there, then it is up to you to change your habits or your thoughts. And I'll leave it at that. And we can discuss anything that you want to put in the comments. Please do. And for anybody that wants to read that book, it's a David E. Robinson book.
Her favorite author.
My favorite author in what we're doing.
So, guys, anybody that's looking to get into the Telegram group, and I even put it in the description tonight, you have to go to the website. You have to pass the quiz. And when you pass the quiz, it generates a link. And then you can get into the site. And it tells you the lettering is like size 36 font. It shows you exactly what to do when you pass it. So that is the only way we're passing out links to the Telegram group. The other thing, I'm just going to touch on this real quick. There's so many people that have asked funds, 1099-A, Treasury back. What? There are no funds right now. The Treasury is backed up. We don't know. We've been asked to stagger stuff. That's all we can tell you guys. We don't know when they're going to process, when they're going to send out funds. and that's it. So all the DMs that I get, all the emails I get, all the stuff asking for fun or has funds come out, has funds come out. I've seen comments in the Telegram group. No, we will be in contact with people if funds come out. And there's a lot going on in this country. I don't think y'all realize the extent of the financial system that is going on. The fact that we have Nasera Jacera going into place. We have revaluation coming in down the pipe. The Treasury is not fully staffed. You got a fake government up here that just put a new Speaker of the House in that's going to take away all the funding for the IRS. Great. They weren't even funding for the IRS anyway. It all went into somebody else's pocket. So there's just a lot of stuff going on. And
quantum
financial system coming out. We don't control what is going on at the Treasury. We have sent bunches and bunches of 1099-As in. They are sitting. We are waiting for things to take place in this country that should have taken place a long time ago. So I know there's a lot of people struggling, but all we can do is be patient. We don't control any of it. We stepped out on a limb to do this and be trustees for people.
I mean, the only thing that our role is, and I think some of the people that have gotten frustrated, our role is to send the paperwork in on your behalf to request the funds that you've asked for in a reasonable manner. And that is it. We don't control anything other than that. When we have the Treasury asking us to stagger documents, we have to abide by that. So no matter how fast you want us to rush that process, first of all, I will not rush it and mess it up for you or for me. I will not ignore what their request has been to us. Okay, I have to do what they've asked me to do, or we can't do it anymore because we have to stagger how many we can send in at a time. So that's kind of where we are. I hope that you can, respect that and understand that, and also understand that, yes, we have taken on a lot. Yes, we are helping a lot of people, are trying to, and, but we don't control any of it. We just do what we've put ourselves out to do, which is on your behalf to send this. And then we wait. And if you are homeless or you are struggling and you're banking on the 1099-A, you're making a really huge mistake. A really, really, really huge mistake. You need to go and learn 15 USC. You need to go and learn Title 11 and Title 12 in your spare time and figure out ways to discharge things without having to go through a 1099-A. Because there are other ways of doing things. And you need to be learning and educating yourself while you're sitting here waiting. But if you're banking on what we're doing to come through immediately, that's not going to happen. So,
also, guys, for all y'all that are in Telegram already and people on here, I put in a link today for Telegram for precious metals. We've always talked about precious metals, the importance of investing in precious metals. It's your only lawful money. So that link is up in the private chat and in the process group. So if you're interested, there's some videos in there. There's a disclaimer in there. You can go in, watch the video, read the disclaimer. And then if you're interested more in knowing more about precious metals and getting becoming a member with that, you can just reach out through a DM or on the Telegram chat, and I will get back in touch with you on that to give you more information. So.
Somebody asked me to repeat the Title 11, Title 12 deal with banking. Title 15 deals with discharging debt, remedies and commerce, stuff like that. So
yeah, staggering means staggering. Like, only send in so many at a time. That's what staggering means, guys.
We can't go every day and take them. We have to go a couple of times a week, and we have to take a limited amount. So,
is Operation Improve Health at Gmail, right?
Yeah. So anybody new that's wanting to do the process to know if we're still accepting, we can help you. You're going to need to go to our website, www.jarrettrealtyinvestors.com, and it'll ask you to take a quiz. We have to do that for competence. If you don't have competence to handle the transactions that we're doing, then you can't get in. And that way we've protected ourselves in testing competence. And then once you get in there, you'll get a link. Once you pass the quiz, you get a link to Telegram. Again, look for it. It's in a 36 font. So, and then everything is under the library tab. You're going to start with the ebook. You're going to read through there. It tells you everything. Read through it a few times. Get familiar with it. And then other document. There's a trustee agreement on our under the library tab, and then other documents that you can look at. Let's see. Let's see. A sole proprietor, can I help people by doing work for it tonight? Can I help people by doing work for a 1099-A? I mean, the turnaround time on getting paid from that is going to be a while. So I don't know who's going to want to accept that and who's not. So yes, whenever we submit, so just because you haven't gotten an email, we've processed everything. You know, we have some things processed here that haven't gone to the processing center. So I let you know when it's gone to the processing center and you've been moved to the process, or you can go and have the link to the process group and be in there waiting. But that's usually once I know that everything has gone to the processing center, then that's who will get notified that your paperwork has been sent.
If you're filing online, I wouldn't.
We're not taking it.
We're not taking online. You need to file it with a hard copy wedding signature on the back, and then mail it to us. The address is in the website. It's also in Telegram.
If your paperwork has already been processed and sent off, and you've got notification of that. It's a $10 fee to add any more that you send to us. It's another $10 fee because that covers the supplies to send it again, whatever we're sending. But you only need one trustee agreement unless you're doing a different transaction later, and then you'll need another one. Jarrett Realty Investors at Gmail is where you're going to get notification from.
Yeah, all that's pinned at the top, guys. So, a new beginning, I will have to check and see. So we sent you an email, but you need more information. I'll just have to see what it is that we sent out. So
we're working on the private banking stuff too. But we are also trying to figure out a couple of other things that might speed up the process too. But I'm not going to come to you with that until I know for a fact that we're ready to go. Yeah, if you've already submitted 1099s to us and they haven't been funded yet, we're not taking any more for that same transaction for 2023. I know we're in 2023, but we're not doing 2023 right now. If you haven't sent us anything and you're filing now, that's fine. But if you filed in 2022 and now you want to jump on it and file for 2023, a house and a car, no, we're waiting until the other stuff gets funded first.
So we're not taking payments, guys, for the 1099A process. There's a 5% commission for us to be a trustee. Once that comes in, the only payment that we ask for is the $10 for the supply fee. I mean, we have absorbed the majority of the cost of all of the ink, all of the paper, all of the mailing supplies, everything that we've done. Folders, this and that, gas to drive back and forth. So that's all we've asked for is the $10 for that. Before, yes, we asked for the $3. That was to pay for y'all's stuff to be filed online.
And we didn't ask for supply fees then because we absorbed the cost of getting all of the folders and envelopes and all of that, and we just can't do that anymore. So
every trustee is going to have a fee, guys. I see Chris is doing grants with the 1099A for all states. There's a fee though. Yeah, I mean,
I don't think is he?
I haven't paid attention to all of it, but I've heard other people comment and I've seen, but I mean, if you're a trustee, you're gonna charge because we're having to, get the funds, pay it out to where it needs to go, do all the things that.
No, we have to hire people. We have to hire people when funds start coming in. The 5% is going towards hiring people that are going to have to help distribute the funds according to trust law. Where we've already got those people in place, but we're going to have to pay them to do the work because they're going to have to be working with us pretty much full time. And then, yeah, just handling all that and the manpower that goes along with doing what we're doing. Okay. So
the link down, I was unable to do it.
Operation Improve Health.
She went to the website. I just
She wants to buy MMS. She can go to
Yeah.
Operation Improve Health at Gmail and do MMS in the subject line, and I'll send anybody that's interested in MMS being added to. If you can't get into the Telegram groups for precious metals, for non-toxic products, and you're interested in that, you can go to our website. There's a drop-down menu where you can request information on those two particular things. I'll send you a link to the Telegram channel on whatever it is that you're interested in. For MMS, if you want to order MMS, you can go to operationimprovehealth@gmail.com. Put in the subject line MMS. I'll send you the information, and it also has a video attached to it that you can watch. If anybody wants their status corrected again with the fee schedule, like I told you about, comes with that too, with at least 20 plus other documents. If you're interested in that, you can put status correction in the subject line and email us at jarrettrealtyinvestors@gmail.com. Secure party creditor process, that's starting up this week. We'll open the Telegram link. If you're interested in SPC, you can drop that in there. I highly recommend you get your status corrected prior to doing that, because that paperwork is the initial. Some of that paperwork goes with the SPC process. So, trust group, again, we have the link for the trust group in here.
And the land patent.
And the land patent.
And the email address are all pinned at the top.
So feel free to join any of those resources that you want to. We have people there to help you. We've worked hard to try to get a network for everything that we feel like is beneficial at this moment. So, let us, I was reading.
What were you talking about? Sorry, I was reading.
I was going to say, let us know if there's anything we can do else we can do for you, but please don't email me that. So I changed my mind. That's where you can get all of that information. We're trying to provide. I know a lot of people are saying you're adding more and more and more to your plate. No, we have people in there that are taking that on for us. I found really good resources to help in all of these areas. So that's why we've added the different niches. It's not because we're taking on a whole lot more. We've got other people handling those. So,
and guys, some of the things that we have to take on to sustain us as well, because if not, we go back to full-time real estate and full-time other work, which means not doing any of this until we get home at night. And that won't happen because we still have to have a life. So, we still have to be able to do things. So,
yeah.
God bless. Thanks for all you do, and God bless the dogs. That was boring. That was a blowout. And the playoff committee is stupid for putting TCU in. So, but all right, guys, we're going to get off of here. Let's end in prayer. And we will come back again next week.
Yeah.
So, yep.
We'll be more frequent now that the New Year's happened. We had a lot of family stuff going on.
Yeah, from about mid-Thanksgiving until after the first of the year, it was constant revolving door with family. So,
okay. Dear Heavenly Father, we thank you so much for this time together. We ask that you would be with us as we go about the rest of our week, that you would just, again, help us to shine a light in the dark world that some of our people are living in. Let's just lift each other up in prayer and not tear each other down as we learn together and work together to try to find freedom for all of us. We thank you for everything. Ask that, again, that you would just be with us as we go about our week. In your precious name, amen.
All right, guys, y'all have a good night. have a blessed week, and we will talk to y'all later.
Oh, and by the way, use that information I gave you tonight. Reasonably, make sure you know what you're doing before you go and just fight a very corrupt system. Okay, just make sure you know what you're doing. That was for education only, so please do some research. And I'll have the writ of discovery up in a few minutes on the website if y'all want to look at it. Thank y'all. Have a good night.
Night, guys.
I'm gonna put that